Hello, everyone. Welcome to Donna Just Being Real, the only way to be. So tonight's topic, bring down the music a little bit lower. Okay, so tonight's topic, we're going to be getting into the evil Zac Stacy bond court hearing and Darrell Brooks' appearance in court. Okay, so I'm gonna be playing two clips. I'm gonna be playing the clips of evil number one, Zac Stacy, his, and then I'm gonna play clip number two, Darrell Brooks, evil one, court appearance. Okay, so welcome to Donna Just Being Real, the only way to be. My channel is about dating, love, relationship, toxic relationship advice channel. So if that's your type of commentary, please feel free to, subscribe and all that good stuff. All right. So thank you to everybody who's coming into the chat, who's here. And all right, let me check these comments. BG, hugs and kisses. Teresa, my dear blessings to you. And don't need a man, stop telling me I do. And mod on deck, Jack. Okay, so we're gonna start off here, and also Jack is co-host, so he's gonna be reading an article too. So we're gonna get into this monster number one. So I'm getting ready to share the screen, and I'm gonna share Zac Stacy. So we're gonna see him in the court. Now this is his first well, he got arrested. I did that already with the commentary that he had got arrested and they caught him, and then he had to go to court for bond. So now I think this is back again with bond. It's a bond court hearing, but this time she was able to come and she was able to speak, because the last time, if you recall, she wasn't able to speak because something was wrong with her phone, so she couldn't get through. Whatever it was a bad connection. Now she came to the court and she wanted to speak to the judge to let him know her side of the story. So we get to hear that one. Then we're gonna get into this evil monster number two. All right, so ladies and gentlemen, just give me a second here while I share the screen. This monster right here, you gotta be kidding me. Okay, I'm gonna pause the music. Okay, I'm gonna pause the music here, and we're gonna get ready to get into this one here and make it bigger. Turn up the volume. It's slightly kind of low, but hopefully you can make the best out of it. So I'm gonna turn the volume up as much as possible for you, ladies and gentlemen. Okay, ready? Let's get into. 1 second. We're gonna get into number one. If I'm correct, I think the beginning there was no audio. I hold second, ladies. Let me see something. Yeah. Let me start again. In the beginning, it's kind of silent. I think there was something wrong with their audio.
Up or point out the prior incidents as well. As a result of all what happened, the judge set a bond of $10,000 on count one, $150 on count two, ordered no contact, ordered that you file your passport with the clerk's office. You posted the bond, you filed the the passport with the clerk's office, and you were released. I set this hearing in very short order. I understand you're residing in Tennessee. You came for the hearing. The purpose of bond is to assure your appearance in court, and I'll note that you've appeared on short notice today for the hearing. The state has filed a joint motion to reconsider the bond and to allow the alleged victim to testify. That's the motion we hear on today. State, do you wish to make an opening presentation? I want you to know, as well as Mr. Luke.
Donna will be right back. There's technical difficulties.
Hello, everyone. Jack, can you hear me? Because I screwed up a little bit. Can you
I
hear
can
me?
hear you fine.
Oh, okay. All right, ladies and gentlemen. I apologize. I don't know what happened with the fooey foo foo foo. We're gonna start again. Unfortunately. All right. Let me just double check here. Okay. Do I have it up? Just give me a second, ladies and gentlemen. Okay, I'm so sorry. I'm gonna have to do this over again. I messed up here. Share. Mhm. Where are you, evil monster? Share. Okay. Everybody see. I will go back just a little bit.
$50 on count two, ordered no contact, ordered that you file your passport with the clerk's office. You posted the bond, you filed the the passport with the clerk's office, and you were released. I set this hearing in very short order. I understand you're residing in Tennessee. You came for the hearing. The purpose of bond is to assure your appearance in court, and I'll note that you've appeared on short notice today for the hearing. The state has filed a joint motion to reconsider the bond and to allow the alleged victim to testify. That's the motion we hear on today. State, do you wish to make an opening presentation? I want you to know, as well as Mr. Luke, that I've listened to the proceeding that occurred at initial appearance court twice. First, when I received the motion, just to understand it better, and second, this morning to refresh my recollection. So I'm fully advised as to what happened at the hearing. If you would like, I'll take judicial notice of that. We would request that, Judge. Okay, thank you. That will be done, and how would you like to proceed?
And the purpose of this mission is really to receive the information that the state had not received at the time, and that was input from the victim. she had planned to be there at 1 o'clock, and I know it was not you, Your Honor, that it was, the case was moved up with little notice.
Yes,
So the point is really just to implement proper safety mechanisms and to just ensure the victim's safety in this case.
I understand.
So we would like to inquire about the address of the defendant, who he's going to be living with, the firearms, are there any firearms? I know he cannot possess it, but does his roommate, does he possess any firearms? Just things of that nature.
Okay, fair enough. Would you like me to inquire of Mr. Stacy of that? Then?
We would, Judge.
Okay, Mr. Luca, I'm going to ask your client questions. He's under oath. If you object to any of those questions, feel free to object. I will not be offended, okay?
Can I just, I'm sorry, Your Honor, can I just make a quick opening statement to address some of those issues?
Sure.
Thank you, Your Honor. Your Honor, just to, and for the safety, notice as well, I filed this morning with the clerk a change of address. Yesterday, I filed a motion, or a response to the state's motion. Mr. Stacy is set to enter into a mental health inpatient treatment facility in Colorado, Edwards, Colorado, starting December 1st. However, between now and December 1st, he is going to be asking for if he can be allowed to reside with his mother in Alabama. And I filed a notice of change of address. I went through this with his probation officer. She has no objection, or she's not probation officer, bail portion. But bail officer has no objection.
Right.
So I did put that in the in my response. But I have no problem with the court requiring us to my client's where he's going to reside, but it will be in Alabama. It will not be in Tennessee. He does not own any possessing firearms, but I have no problem with the court requiring that.
Okay. So State, have you received a copy of the notice of change of address indicating the address in Alabama?
We have not.
Okay, here's a copy of it. It's been filed with the clerk, so you'll have access to it. So we have the answer to your first question. Okay, Mr. Stacy, I'm going to ask you some questions. You can stay seated. You're under oath, and I just need you to speak loud enough for me to hear you. Can you do that, sir?
Yes, sir.
Okay. So I have an address of where you're going to be residing in Alabama. Is that with your mother?
Yes, sir.
Who else resides there with your mother at this time?
My little brother.
And how old is your little brother?
He's 24.
Okay. And how old are you?
I'm 30.
To your knowledge, are there any weapons in that or firearms in that house?
No, Your Honor.
Okay. A condition of your release is that you not possess any weapons or firearms. You understand that?
Yes, Your Honor.
Violation of that condition can result in your incarceration and most likely not another bond set, although I can't promise that, but it would be a bad situation. You understand?
Yes, Your Honor.
Part and parcel of that is you cannot be in a house with a firearm. So if there are firearms in the house that you become aware of, or if you make a phone call to your mother right after this hearing, they need to be removed from that household because I don't want you residing in a house with a firearm. You understand?
Yes, Your Honor.
Can you follow that condition?
Yes, Your Honor.
Your attorney just informed me that you intend to enter a program in December in the state of Colorado. Is that correct?
Yes, Your Honor.
Is that an inpatient program?
Yes, Your Honor.
How long is that program?
30 days.
Then you would be out presumably at the end of December, or maybe January 1st even, depending on how long the 30 days is in their opinion. When you get released from that program, where do you intend to reside?
Just go home back to Alabama.
Okay, back with your
Find a
mother.
place of residence myself.
Okay, so if I ordered that except for the time that you're in and participating in the inpatient program, you will reside at the Alabama address you just provided, you can comply with that.
Yes, Your Honor.
If you wish to move to another address, you're free to do so after your attorney files a motion, and I approve that. I just want to know where you're living, okay?
Yes, Your Honor.
And you understand that there's a condition, you have absolutely no contact, either directly or even indirectly through your mother, brother, family members, or friends with the victim in this case.
Yes, Your Honor.
And you can comply with that as well, correct?
Yes, Your Honor.
State, is there anything else you'd like me to inquire? I think I answered all the concerns.
Judge, if we could also inquire if he also has a residence in Orlando.
Okay. The location where this occurred was, I believe, an apartment. Is that apartment in your name?
No, sir.
Okay. Do you have any leases, or do you own any real property in the state of Florida?
Yes, Your Honor. I have a lease.
Okay.
Jack, I'm done.
It's
You're right.
Okay. And are you planning or do you intend to return to that location? No, Your Honor. Okay.
Frugal. Hugs and kisses, beautiful.
Okay, today is June 1st. Please say your name and spell it. I'm
Counsel for the victim would like to speak, Tom Crider, and present a statement as well.
Okay, I understand. Is there any other information you would like me to obtain from Mr. Stacy? For the state? Okay. Okay. Thank you, Mr. Fider. If you'll stand and approach the lectern where there's a microphone and present whatever you wish.
Good morning, Your Honor. I'm Thomas Fider, as victim counsel for Kristen Evans here. As I'm sure the court's aware, Article 1, Section 16 of the Florida Constitutional Amendment states that victims have the right to have their safety and welfare, as well as their families, considered in setting bail, including setting any pretrial release conditions that could affect the safety and welfare of the victim. Ms. Evans has not yet been given that right. We appreciate the court giving her that opportunity here this morning. So with that, I'd like to call Kristen Evans. May she stand here next to me or to give her statement?
Is she more comfortable standing there next to you?
I think she would be best.
And you'll come up to the lectern here for me. Once you arrive, you can raise your right hand or place your other hand so I can get your hand.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Yes. Thank you.
Put your hand out. Tell me your full name, please.
My name is Kristen Evans.
Okay, thank you. You may inquire, Mr. Fider.
Thank you. So Ms. Evans, I understand you have a statement that you prepared and a few things you want to share with the court this morning. Is that correct?
Yes.
Okay, you may, of course, share your thoughts with the judge.
Thank you, Your Honor, for being here today. My name is Kristen Evans, and I'm the victim in this case. I have a 12-year-old and a 5-month-old that I'm a primary caregiver for. You've seen the video, what he did to me. I was slapped, punched, literally picked up and thrown into my TV, and then picked me up and slammed me into my son's bouncy seat by my throat. This is not the first time that he's been violent with me. I am afraid for my safety and for my children's safety. He was released on the weekend, and I was too afraid to go home. I have not been back home yet. My injuries from this incident are serious and likely permanent from what I have been told. I'm just asking the court to increase his bond, place him on home confinement, and make sure and verify his residence and make sure there are no firearms in the home.
Okay. I believe from the report you were concerned, it might have been in the injunction request that you might have had a fracture and you went to the hospital, as I understand it. Is that correct?
That's,
To your knowledge, was anything fractured?
no, sir.
Okay. Have you been home since this incident? Or you have not?
I have only been home to grab items with police escort.
Okay. Have you had, or let me rephrase that, has Mr. Stacy had any contact with you since he's been released?
Yes.
Okay. And do you have a relationship with his mother?
Not any longer, sir.
Okay.
Ladies and gentlemen, I have to pause. I'll be pausing now and then. This is amazing. Just look how he's just sitting there like he's just so calm, like he didn't do anything, like he's just just a good guy. Why are you doing this to me? Do y'all see this? This is a sign of madness. This is a malignant narcissist. He's completely out of his mind. I will resume.
Anything else, Mr. Carter? Any other questions?
No further questions of Ms. Evans, just some closing statements.
Okay. You've been here for 1 minute. Mr. Luca, do you have any questions?
Very briefly, Your Honor. Ms. Evans, I don't want to talk to you back. Isn't it true that you, between the time of the original incident that this occurred and today, there was an intervening car accident that you were involved questions I have.
Okay, thank you. Mr. Fire, any follow-up questions?
No, thank you.
And State, do you have any questions? Okay, thank you. Anything else, Mr. Fire?
Yes, just very briefly, Your Honor, if I may. Your Honor, it's our argument that the defendant is violent, he is dangerous, we've heard.
That's the one got thrown to the TV, right?
Seen some.
Yes, that's her. That is her.
Okay.
Okay.
Dang, she sure can take some hits.
I will resume, Jack.
Of what he's done to her. We've heard that she's feared for her life and the life of her children. We consider him to be a very dangerous and violent man. After this happened, he fled the state. I'm asking the court to, well, you've already inquired of where he will be staying, who he's residing with. And we've talked about his local residence here that was not shared with the initial appearance judge. We're still unclear why he gave an address in Tennessee, but in the end, we're asking the court to increase bond amount to order that he be placed on home confinement or some measure of protection, so that if he is to leave the address that he just filed this morning, that our client is notified of that, so that she can be aware he may be returned to the state of Florida. Obviously, it's our preference that he doesn't return to the state of Florida. The order asks that there be no firearms in any home he resides with, and continue to, as we have here today, respect the victim's rights. Thank you.
Mr. Fire? Okay, State, any argument? I believe it's your motion.
No argument, we did coordinate our response. I would have to note, though, I do have to let the court know that the address that was given to the IA judge in Tennessee, there is some correspondence that we'd like to see that when he gave that address to the court, he actually was not allowed to be at that address. There was another party there, there was a custody order, and he was not allowed to be at that address. So that's just clear.
There was a lot apparently that happened at that hearing that was unusual, to put it kindly. I really thank you.
Thank you.
Okay, Mr. Luca, argument?
Very briefly, Your Honor, the rule that governs pretrial release for Rule of Criminal Procedure 3.131, specifically D, in order to change the bond conditions, the court must be made aware of new information that was not known at the time to the magistrate of the original initial appearance. For the record, last Thursday, so just so we're clear as to how these events unfolded, immediately upon learning that there might be a warrant, before even the warrant was actually confirmed, Mr. Stacy retained our firm and myself to try and inquire as to finding out the warrant. Apparently there was some issue with how the warrant was initially submitted to the court, specifically to the spelling of Mr. Stacy's first name, one letter off. He actually tried to turn himself in Nashville when he thought there was a warrant outstanding, but there was no warrant because it was under the wrong name. That was since corrected by Detective Dozier on November 17th of the Oakland Police Department. He confirmed that with me at 4 o'clock. I immediately got on the phone with Mr. Stacy. He immediately flew and came into Orlando. The plan was originally that I was going to pick him up at the airport.
5 bread.
Jail and surrender him. However, apparently someone recognized him on the plane, and he was arrested and taken into custody by the Orlando Police Department. Either way, Your Honor, my client was not trying to be a fugitive of justice. He was not trying to flee the state. He was not trying to hide. He was trying to resolve this matter as quickly as possible. As far as the first appearance is concerned, that also was odd because, again, when I was informed of first appearance, that first appearance was going to be at 1 o'clock in the afternoon on November 18th, that was the night before, on November 17th. The morning of November 18th, I received a call from Judge Baines, the initial appearance judge's judicial assistant, indicating that they wanted to move the pretrial up to 10 o'clock in the morning because, specifically that's the only reason why it was moved up. So it was not moved up because of me or because of anything else. It was moved up, as far as I know, because of Judge Bain and his understanding of conversations that he had with the state there.
I never thought it was moved up because of you. That's not a problem.
Okay. Or Mr. Stacy, I'm just want to let the court be aware of how this was, you're right. So initially, there was not, and again, I was not even given, there was not paperwork after the initial appearance to even review or time to review it because of the quick turnaround that we had. I had court here before Judge Adams at 9 a.m. and had to run immediately over to the jail to deal with the situation. So you're right, Your Honor, certain things were said in court that were unknown to me. However, they were brought to light. The injunction information was presented to Judge Bain, so that was known to him at the time. He imposed a bond that is in excess of the standard bond schedule pursuant to Administrative Order 0798-4717, and the most recent one, 2003-3924, which sets the Orange County bond schedule. Plus, also additionally, he imposed the additional condition of surrendering Mr. Stacy's passport, which he did. He did provide that address because that was he only provided the address in which he was staying at his last known address, so that was the only address he had at the time. That's one of the reasons why we're filing a change of address today, because we realized that because of this pending custody order that we were not aware of at the time, but since we've become aware of, Mr. Stacy cannot live there, hence he is now going to be living with his mother in Alabama until he goes to his program in December, and then will return to Alabama until he can get his own residence. So it's again not a fault of Mr. Stacy that this custody order prevented him from residing at that residence because no one knew that was actually an issue at the time. So I understand that this is an unusual case, an unusual set of circumstances that have led up from surrender to now. However, none of those were the fault of Mr. Stacy, and I don't think any additional conditions of bond are necessary, including home detention or any sort of ankle monitor or anything along those lines. It's going to further protect Ms. Evans from contact with Mr. Stacy. Mr. Stacy will be living 2 states away, actually 3 states away, and until December 1st, in which then he will be at least 2,500 miles away. So I think there's adequate safety precautions in place, and that the state, to satisfy the state and Mr. Fletcher's client, that Mr. Stacy is not a danger to her, her family, anyone else, and he does not intend to return to the state of Florida until he has to for court.
Okay, two states away. Part of Alabama and Florida are contiguous. However, let me ask you, and you made the statement, and it was going to be one of my questions, so I'm glad you brought it up. If I entered an order modifying the bond to prohibit Mr. Stacy from returning to the state of Florida except for court appearances, that's something that he could comply with?
Absolutely, right. No problem with that at all.
Okay, thank you.
Your Honor, I'd like to briefly respond if I may. To what Mr. Luke was saying, I don't know where he's getting his information, and I'm not saying he's lying, but the information he just provided to the court was not true. Yes, sir. It was not accurate. Our client, Ms. Evans, had planned on attending the initial appearance in person. She communicated that to the court personnel. For whatever reason, it was moved up. She told them she was in the hospital, she was trying to be heard, and her voice was effectively silenced. So
It was, which is why we're having a hearing today. So
yes, sir.
all that has been remedied. New information I've heard that the initial appearance judge did not, it's her testimony.
Yes, sir.
So I agree that would provide information if I thought it was appropriate to modify the bond. Okay, thank you. Okay, Mr. Stacy, the purpose of bond is to ensure the safety of the community, and the primary purpose is to ensure your presence. Again, I gave your attorney very short notice for this hearing because I thought it was very important, and I thought that the victim should have her voice heard. It should have been heard on November 19th. It wasn't. We heard it today. I'm not going to modify your bond amount. I think the amount is appropriate only based upon your appearance today. And so I'm not going to increase the amount. I'm going to modify a condition of the bond that you not enter the state of Florida except when there's a scheduled court hearing, and that you not reside anywhere other than the Alabama address you provided where you reside with your mother, except for the time that you were in and again, that's subject to modification upon motion, not upon you wanting to do it on your own. Does that make sense?
Yes, sir.
And to be clear, you were to have no contact whatsoever, directly or indirectly, with, is it Miss Evans?
Yes, sir.
With Miss Evans in this case. State, as you're aware, the Ninth Circuit not only doesn't have an ankle monitor program, but specifically prohibits the ankle monitor program from being used, so I cannot authorize that today. Are there any other conditions you think are necessary for the safety of your victim?
Just reference, weapons and firearms.
Okay, which has already been referenced, so I'm only modifying by adding, not subtracting any of the conditions. All the original terms and conditions of the bond set at initial appearance, so shall remain in full force and effect. That should assist you in that. Mr. Luca, anything, any other concerns?
Yes, just very briefly, Your Honor, my client just informed me he does have some property at 55 West address. He just asked him to be allowed to go to that address today, obviously, before he leaves back to go to Alabama, to get as much stuff as he can, pile in his car, and to go.
Okay, so you drove down here, Mr. Stacy? Correct. Okay, and is it your intent to leave today or tomorrow?
Today.
Today, okay. You may remain in Florida. You can go to your address at 55, is it West Central? Is that what the address is?
55 West on Church Street.
West Church Street, okay. To retrieve your items with the understanding you're gonna have no contact with Ms. Evans, not go to the location where this event allegedly occurred. And you will, on December 1st, participate in that program in Colorado.
Yes,
Any questions about what happened here today?
No, Your Honor.
Okay, anything else, Mr. Luca?
No, Your Honor.
Okay. Mr. Fiver, anything?
No, thank you.
Okay. Thank you all very much.
Thanks.
Thank you for addressing this so timely.
I thought it was important. Thank you.
A mountain of toys.
They need to keep him away from buying 65-inch screen TVs.
That's insane. And she wanted to hire Bell, but they didn't give it to him. It's messed up. It really is. Okay, anything else you would like to say before I move on to the next evil person?
I'll say get a gun, ladies, and get comfortable using a gun, or get a mean dog if you don't like guns.
I have a point. Because I know one thing. I was trying to look it up, but I didn't see anything. But I think eventually it's going to come out. I know that this is not the first woman that he put his hands on.
Yeah,
He's done this
first.
before. But I guess when they, go to court and
He
all that
just
kind
got
of stuff.
caught on camera.
Yep. She had a
Throwing her
camera.
through the 65-inch screen TV.
Yep. She had a camera every angle too. Every angle. Okay, ladies and gentlemen, want to know this is kind of going to be a long live stream because each court thing is like almost 30 minutes. So I'm going to show the other court one about this other devil's helper too. We got Darrell Brooks here. Yeah, this one here is a monster. So Jack is going to introduce this. He's going to read an article, and I'll show a couple of pictures. So he's going to get into this one, this other monster. Okay. Teresa Myers, hugs and kisses, beautiful. All right. You ready? How you want to do this? You just want to? Okay.
Yeah, I'll go ahead and do it. Unless
All
you
right,
want to share the.
Hold it just a second. Just a second. Okay, we're gonna get into this monster right here. Let me do this correctly. Sorry. Okay, we're gonna get in this monster right here. Look at all the faces of evil. He hasn't been crap since the day he was born. Let's look at all these times that he's been arrested. He's just a piece of crap. He's just straight up low life. His mama, his daddy, no. They laid down and made Satan Jr. too, just like the first one. He's a dangerous person. And a little bit that I was reading, and that Jack had did commentary on his channel too about this. Why was he out on the streets? I just don't understand. Hmm.
I
Okay,
mean, he has so many opportunities to get it right, and unfortunately, it just gets worse and worse and worse. And it seems he just doesn't have a life, with those elf ears that he has, looking like Lord of the Rings character. Um, but let's go on. All
okay.
right.
You want to? How do you want to do? You want to share it, or you
Yeah,
just
yeah, sure, yeah, sure. I'll share it.
okay?
Let me do this right here. I think this. Okay, yeah. Can everyone see that?
All right, let me. I keep forgetting to press the button.
Yeah, there
Okay,
we go. Let me
let's.
zoom it in a little bit more, just to. There you go. Okay, set. Okay,
Okay,
there it is. That's better. So everybody can see it.
okay. Go ahead.
All right. It's from the Sun, and it says, "Mommy's boy."
Yep,
Mommy's boy. What a
that's what I
bum.
be talking about, Jack. These parents, they know their kid ain't crap, but they just be enablers. And
Mhm.
it really bothers me about that.
Yeah.
Okay, I'll let you go.
Darrell Brooks talked to himself and lived with mom. What a life. Claim neighbors who think he snapped in Waukesha parade horror. The suspect who allegedly drove through the Waukesha parade was seen talking to himself. That's the crack talking. Claim neighbors who think he snapped before the SUV rampage.
Mm, mm,
Darrell Brooks was always a little off. One neighbor who didn't want to be identified exclusively told the Sun at his home in Wisconsin after the car was seen plowing into the festival crowd filled with elderly people and kids. Look at that. I swear he looks like Lord of the Rings character. Look at those ears.
mm-hmm,
Look at
mm-hmm.
that. Look like Igor or something. Look at this Igor looking character. And he's rapping in the video with the same vehicle. You see this?
Yep. Mm-hmm.
Oh
Mm,
boy.
mm, mm.
And I didn't know him more than high and by, but I remember seeing that red truck parked there. They said this vehicle, the neighbor reference, was seen in a horrific video speeding through a crowded Waukesha, Wisconsin Christmas parade on November 21st. 5 people died and more than 40 people were injured, including 12 kids, in the chaos as families and performers celebrated the annual holiday event. The victims were identified as Virginia Sorson, 79, Leanna Owens, 71, Tamara Derlin, 52, James Coolidge, 52, Wilhelm Hospo, 82. Officials said on Monday that 18 children were treated at the Children's Hospital Wisconsin following the
Mm,
alleged
mm, mm,
rampage.
mm, mm.
Brooks was arrested and charged with 5 counts of 5-degree homicides. I mean, first degree homicides, not 5-degree homicides. Don't make no damn sense. But he must have snapped. Another neighbor Ebony told the Sun, "The whole thing's messed up, but it doesn't surprise me." Okay, it doesn't surprise you, but you didn't do nothing. Others told the Sun that they have seen him around the neighborhood, but never interact with him. Others say they didn't know who he was. No one answered the door to his home that neighbor said he shared with his mother. The streets on both sides of the Brooks house were otherwise quiet Monday night. A few cars came and went. Some neighbors returned home and say they heard about the incident but didn't realize suspect lived on their block. Okay. One of the child's victims, Jesselyn Torres, who was taking part in the parade with the Waukesha Extreme Dance Group. She was with her mom, Amber Cohen, and her 2-year-old sister, Avery, when she was struck by the SUV. She remains in hospital fighting for her life with a broken pelvis and lost a kidney. She also has lacerations on her lungs and remaining kidney and suffered from internal bleeding. As a Monday
Donna.
night, a family friend told the Sun she was sedated but stable. Ryan Colling, Jesselyn's uncle, told the Sun her mom and dad are now with her at the hospital. They will not be leaving her side. The rest of us are going to make sure the other kids are taken care of throughout this. Cohen explained that Jesselyn's mom, Amber, has 4 kids, with the eldest being 16 and the youngest age 2. We're getting a lot of support from the community, people reaching out wanting to donate meals. We're organizing this. A family friend started a GoFundMe for the Colin family. They're good kids, always having fun. The family friend Oscar Luna told the Sun, each one has a unique personality and gets along extremely well. Videos posted on YouTube by Brooks appear to show the same car that plowed into parade. The first 3 letters on the license plate, ADP, and the vehicle's description are the same as reportedly heard on the police scanner. Court documents link Brooks, who wrote about killing people concerning rap lyrics, to the address in Milwaukee where he was arrested. Brooks, a convicted sex offender. Let's repeat that again.
Yep.
Brooks, a convicted sex offender, for those who want to support him, also had an active arrest warrant in Nevada for failure to obey sex offender laws, according to the Washoe County Sheriff's Office. He was convicted in 2016 of fathering a child after having consensual sex with a 15-year-old girl. Wow. Okay. So he was like in his late 20s with this girl. Kind of like R. Kelly. Brooks was placed on probation until he was arrested for failing to follow sex offender laws in 2016 and has an open arrest warrant after jumping bail on that charge. Brooks was released on $1,000 bail 3 days before he allegedly plowed through the parade barrier and left behind a trail of carnage. Of course, these are some of the people that died.
So sad.
One.
And Jackie, look at them. They kind of like, they older people, and it's like they probably was worried about once again, catching the virus. That would be the one that would kill them.
Yeah, they caught the
like
virus. It's called the degenerate virus.
Mm-hmm. Well said. What is that clip? Should you show that one? What is that?
Yeah.
Okay. Oh, it's on the other thing too, but just show it.
Hey, I called an Uber and I'm supposed to be waiting for it over here, but I don't know when it's coming. Can you call it for me, please? I'm homeless. I don't know. It's him. Oh, yeah, for sure. Yeah. That's my ID. My ID. Whoa.
26, 500 block of Elizabeth, 126. Hey, do you know this guy? Absolutely not. No. Okay.
All right. All right, I think that's it.
Okay. I will share the screen and play the court footage of him in court. So we're gonna listen to that one. This is like about 25 minutes long, ladies and gentlemen. So I know it's kind of a long night. Alrighty. Let me. What is wrong with me? Okay. I'm gonna get into him in court. So I'm gonna share the screen. And thank you, Jeff, for reading that. I appreciate that. Thank you. I forgot the other article because Lisa had sent to me about it was something. It was a GoFundMe. Oh gosh, I forgot all about that one. All right. All right, let's get into this monster here. Let's get it. Oh,
All right. Thank you. And could we hold just a second, please? Hold. So folks, we're going to get started. I know emotions are running very high on this case. If you feel like you need to step out of the courtroom, please do. I'll expect everybody to conduct themselves in an orderly fashion, despite some of the allegations you're about to hear. If you feel that it's too much for you to hear, please step outside. Also, audio and visual are not allowed here via a Supreme Court order. We have one camera that's a pool camera. So that's all that we're doing here today. So please refrain from recording or videotaping this. So with that, if we could proceed. This is case number 21 CF 1848, State of Wisconsin versus Darrell Brooks. Matters tabbed to Judge Lau. Appearance by the state, please.
Good afternoon, Commissioner Sue Opper and Leslie Basie appearing for the state of Wisconsin.
Thank you. And for Mr. Brooks.
Darrell Brooks appears in person in custody with attorneys Anna Keyes and Jeremy Perry. Good afternoon.
Good afternoon to you. And we are here on a criminal complaint that's now been filed. Mr. Perry, will Mr. Brooks acknowledge that he has received a copy of that complaint and will he waive its reading in open court here today?
We have received copies of the criminal complaint. We waive formal reading.
Thank you. It may at some point be relevant, but the address on the complaint is accurate.
That's right.
Thank you. And Mr. Brooks, I have reviewed a copy of this criminal complaint. I will find it does state probable cause as to each of the 5 charges before you. You're charged in count 1 with first-degree intentional homicide. That's a Class A felony, and that has a maximum possible penalty of being sentenced to imprisonment for life. That's for victim A. Count 2, first-degree intentional homicide regarding victim B, is a Class A felony. Again, the maximum possible sentence is a sentence to imprisonment for life. Count 3, first-degree intentional homicide regarding victim C is again a Class A felony, and that's punishable by a sentence to imprisonment for life. Count 4, first-degree intentional homicide regarding victim D, again, is a Class A felony. That's punishable by a sentence to imprisonment for life. Lastly, count 5, first-degree intentional homicide regarding victim E is a Class A felony. That is punishable by a sentence to imprisonment for life. As those are felonies, you're entitled to have counsel. You're entitled to have also a preliminary hearing. And I, again, have found probable cause to each of the 5 counts upon my review of the pleading. So we will turn to Attorney Opper for her bail recommendation.
Thank you, sir. As to bail recommendation, Your Honor, I'd like the court to be aware of a prior criminal history as it relates to Mr. Brooks. I can advise the court he has arrest record from 3 states to include Wisconsin, Nevada, and Georgia. Starting with the state of Wisconsin, the record begins in 2000. There was a conviction in that year for substantial battery, party to a crime. A prison sentence was imposed but stayed for 3 years probation and 6 months condition time. 2002 conviction for possession of marijuana as a repeat offender, sentenced to 50 days in the House of Correction. 2003 misdemeanor conviction for resisting obstructing, sentenced to 20 days in the House of Correction. 2005, there's an arrest from Langlade County. Ultimately, he was convicted of a county ordinance violation for disorderly conduct. What's remarkable about that is that he failed to pay the fine, so he was ordered to serve 30 days in jail on the non-payment. 2009 Manitowoc County conviction for obstructing an officer, sentenced to 2 days jail time served. 2010 conviction from Wood County, Wisconsin. He was convicted of the offense of strangulation / suffocation with other charges of battery and criminal damage to property dismissed and read in. The court ordered a withheld sentence for 3 years probation. That probation was revoked, and on August 1 of 2011, he was sentenced to 11 months jail. 2012, he was convicted at the same time on 2 separate files in Milwaukee County. First file was a charge for possession of marijuana as a repeat offender, sentenced to 180 days in the House of Correction. The second file, he was convicted of misdemeanor bail jumping and misdemeanor possession of THC, also sentenced to 180 days in the House of Correction, concurrent to the other case and concurrent to each other. In May of 2012, there was a conviction for resisting obstructing. He was sentenced to 37 days jail consecutive to the earlier sentence imposed in April of that year. He's currently pending on 2 charges in Milwaukee County. 2020 CF 2550, he's charged with 2 counts, second-degree recklessly endangering safety while armed, and 1 count of felon in possession of a firearm. The date of that offense, or excuse me, all 3 offenses, is July 24 of 2020. It's believed he was arrested shortly after that incident and remained in custody in the Milwaukee County Jail until released on bail there for reasons of a speedy trial violation on March 3 of 2021. Bail at that time was lowered from $7,500 cash bail to $500 cash bail. In that case, Your Honor, it is alleged that he got into a fight with his nephew. The defendant fired 1 round from a handgun toward the vehicle that his nephew was in. The vehicle was occupied by another person, and that accounts for the 2 charges of reckless endangering safety. The next day, he was taken into custody, and the residence where he was located, he was found to have a loaded 9mm handgun just a few feet away from him. The handgun was previously reported stolen. Again, he was a convicted felon on that date, so that accounts for the 3rd charge. He's also currently pending in Milwaukee County case number 21 CF 4596. That has a date of offense of November 2, 2021. He's charged there with resisting obstructing, felony bail jumping, second-degree reckless endangering safety in a domestic violence situation, domestic DC, and domestic battery. The allegations in that case, Your Honor, are that he struck the mother of his child in the face with a closed fist. Then as she was walking away from him, he intentionally ran her over with his vehicle. The vehicle in that matter described as what's believed to be the same maroon 2010 Ford Escape used in the allegations.
Why was this
in
man
case.
walking the streets?
Police went to his home and found him getting out of that Ford Escape. The defendant ignored their commands to stop, and he tried to run into the house before he was apprehended. There's a long history of flight, obstructing, bail jumping type behavior, Your Honor. It's remarkable that these are violations all around the state of Wisconsin, not just his home county of Milwaukee, but we had convictions from Wood County, Manitowoc, and Langlade. I'd like the court to be aware of a record from the state of Georgia, Nevada. We'll go to Nevada first. That happened, the first conviction was from December 11th of 2006. He was found guilty at trial of a misdemeanor count for obstructing an officer, was sentenced to jail in Nevada. Also on that same day of December 11, 2006, he pled guilty to a domestic battery as a misdemeanor, and the court there ordered a suspended sentence. On March 16th of 2007, he pled guilty to statutory sexual seduction, a felony. The court ordered a suspended sentence for 36 months probation. He was also ordered to register on the Nevada Sex Offender Registry. He is currently noted to be non-compliant with that registration requirement. On June 23rd of 2016, he was charged with a sex offender registry violation, first offense. He failed to appear in court, and a warrant remains active for his arrest. So he currently has an outstanding warrant for his arrest in the state of Nevada. In Georgia, Your Honor, the record reflects a May 27, 2021 arrest for misdemeanor battery with a designation of family violence. While it is not clear if he was convicted, he did recently remark to a court official in this county that he had served a 6-month jail sentence in Georgia. So we have not been able to verify if that was a conviction, but certainly there was a confinement in conjunction with that arrest. He has no contact with the criminal justice system in Waukesha County or the district attorney's office. He does have a outstanding paternity case that's been pending since 2003, in which he was adjudicated as the father of a juvenile.
Who the heck would
And
want to
there's
lay
been,
down with this piece of crap and make a
returned
baby?
court appearances over the years based on failure to pay child support. The court should know that a warrant or capias was issued for Mr. Brooks in this paternity case on at least 8 occasions. He has been sentenced to jail on several prior occasions for failing to pay that child.
And he's a super bum.
And on one occasion, he had his super privileges revoked related to one of those jail sentences. That was back in 2009. Most recently, there was a warrant issued for his arrest in that non-support civil case on August 2 of 2021. Judge Maxwell signed an order for him to serve a 120-day jail sentence. Mr. Brooks did make a court appearance in that matter on November 16th of 2021, so just last week, 1 week ago. And
they
he
would
was
lay down with
released at
him
that time because,
unprotected,
again, he
BG.
had explained to the
Oh
court,
my God, you need
provided
like
an
4 or 5
explanation
pounds.
that,
You shouldn't be sleeping with some crap
the
like
reason
this.
he had not made his child support payments is because he was serving that jail sentence in Georgia. So the court released him that day and ordered him back for a court appearance in the paternity case for December. So Judge, just based on his prior record, we obviously have very significant concerns about Mr. Brooks' flight history and willingness to obey the orders of the court. But we have to factor in, obviously, the allegations in this case as well. And obviously, I don't need to state Mr. Brooks is facing 5 consecutive life sentences if he's convicted on all counts in this complaint. I wish to notify the court, sadly, that today we learned of another death of a child related to this case. We do expect a 6th count for first-degree intentional homicide to be issued or added, to this case. I can advise the court that I am aware, I've been made aware through investigators that there are other individuals in critical condition. I think we remarked on the number of actual injured parties in our complaint. It exceeds 60 people. There's a number of other charges that we are reviewing and considering, but certainly at the very least, we do intend to file a 6-count of intentional homicide, maybe Friday or maybe early next week, depending on when we can accomplish that. Certainly, if we have any other deaths resulting from this incident, additional counts of homicide will be filed. We didn't charge bail jumping. Obviously, we could have. We have focused our efforts to date on the immediate concern, and that involves the loss of life that is alleged to have occurred through the conduct of Mr. Brooks. I want this court to know, and I think the court has read the complaint. You've indicated you've read the complaint. There are not words to describe the risk that this defendant presents to our community, not only flight risk, but the dangerousness that he presents, his history of violence, and the allegations in this complaint where it is stated plainly that on several occasions he was told to stop by police officers. They risked their own safety to try and step in front of the car to stop him. Everything was done to get him to stop, and he just simply continued down the roadway, causing death and destruction in his path. So I am advocating for a significant cash bail, Your Honor. I'm asking for $5 million cash bail. I know that's a large amount of money, but I think it is warranted on this history, and I think it's warranted when the court considers, if convicted, Mr. Brooks will spend the rest of his life in prison. Thank you.
Thank you. Attorney Perry.
Thank you, Commissioner. When this court determines what amount of monetary bail is reasonable and necessary to assure
I
Mr.
agree with
Brooks'
you,
appearance in
BG.
court,
What's wrong with these
I guess
parents?
at today's hearing, the only thing I would add for the court's consideration is that Mr. Brooks is financially indigent, does qualify for public defender representation, and that individual circumstance must be taken into account.
Does that conclude your argument?
It does.
Thank you, sir. So first of all, let's get to conditions of bail. The monetary portion is called bail. There are conditions, though, in bail. And first, I am going to order, sir, level 4 monitoring through WCS if you do post bail. You're not to leave the confines of the state of Wisconsin. You are only to be released on a business day during business hours. He's the highest ranking sheriff, deputy sheriff. I would like your opinion. I would like the sheriff's department to notify WCS if he bails out, that he's to immediately go over to WCS. So would it be asking too much if I had somebody from the sheriff's department contact during regular business hours, WCS, to let them know that he's being released? Then I'm ordering then that the sheriff's department contact immediately upon Mr. Brooks walking out the door, if that should happen, that he's on his way to WCS, which is literally a block away. If that does not happen, I want to make sure that people are aware that he did not get on the GPS monitoring device, which I am ordering. I'm ordering him to pay for that as well. Again, he's only to be released on a business day during business hours, with the sheriff's department agreeing to contact WCS. If WCS does not have Mr. Brooks come in with a matter of minutes, I would like them, I'm ordering them to then contact the sheriff's department of that. I am ordering, sir, that you not operate a motor vehicle. You may not possess any dangerous weapons or firearms. You are not to have contact with the families listed in the victim identification sheet. You are to only disseminate that information to your lawyers. Those are all the conditions of bail. If you violate any condition of bail, including failing to return to court, separate bail jumping charges could be issued against you. In reviewing 9
Great point, BG.
69.01
Why is he getting
of the
bail?
Wisconsin
This
statutes
doesn't
and
make sense.
969.001 that talk about bail and release. The statute reads that there should be reasonable conditions designated to assure his or her appearance in court, Mr. Brooks, protect members of the community from serious bodily harm. And those are the conditions that I just laid out. The bail may be imposed at or after the initial appearance. There should be a reasonable basis to believe that bail is necessary to assure appearance in court. Some of the things to be considered by the court with the conditions of bail are the number and gravity of the offenses, the potential penalty the defendant faces, whether or not the allegations are violent in nature, the prior record of the defendant, character and strength of the evidence which has been presented to the court, whether the defendant is already on bail or subject to other release conditions in other pending cases, and whether or not there's any violations of those release conditions. In reviewing the criminal complaint, the allegations are such that I read that 2 detectives opined that this was an intentional act, that the vehicle seemed to swerve into individuals, actually at one point trying to avoid other vehicles, that the detectives, they're listed as Detective Casey and Detective Chusoni, who again opined that the actions they observed, in their opinion, were intentional. We now have 5. Attorney Opper informed us of a 6th, but that's not here before us today. 5 people that are deceased. We have a gentleman that has a huge background via multiple states. Just going through some of the Wisconsin cases, they're violent. We have substantial battery, DC, strangulation, suffocation, resisting. Pending cases, which the statute I just read references that I should consider: second degree reckless endangering safety while armed, felon in possession of a firearm. Attorney Opper told me that the gun apparently was a stolen handgun. Those are allegations. He's out on bail on that. Also out on bail on the Milwaukee case ending 4596, where he's charged with second degree reckless endangering safety, disorderly conduct and battery, and resisting. And then we get into Nevada: battery, the domestic violence, the sexual assault, the sex offender registration violation, and then the battery in Georgia. Other considerations are on WCS, their report indicates level 4 monitoring, which is the highest level of monitoring that we have. And in that report, it does indicate there have been failures to appear other than 2 years old, and then sentenced to incarceration prior, yes. Current violent felony, yes. Or offense, yes. Pending charges at the time of this offense, yes. Prior misdemeanor convictions, yes. Prior felony convictions, yes. Prior violent conduct or conviction, yes. Prior violent convictions, 3 or more. So there have been missed court dates, although none
This is truly
in the past 2 years.
Hey, Free
But
Thinker,
then we just
hugs
heard
and
about
kisses,
a rather
lady.
significant
Welcome
duration
tonight.
of a 6-month stay in Georgia in custody there. In the recitation by Attorney Opper, we have things that causes the court some pause for concern: resisting. Again, these are things that would cause me to feel that this gentleman does not follow rules very well. Orders of the court, orders of society, resisting an officer. There's a bail jump in 2012. There's a bail jump charged in the 4596 case. There is in the 2550 case, again, the felon in possession of a firearm. All those things are just societal legal issues, also orders of the court in some instances that are not being followed. While out on bail on 2 rather significant allegations, we are now faced with 5 counts of first-degree intentional homicide. So when I look at that, I look at the gravity of the offenses, the maximum possible penalties as the statute allows for, likelihood of incarceration, which if you're found guilty of 1 or more of these, even 1 would put you in prison for the rest of your life. I believe you are a flight risk. There's failure to follow court orders. This allegation, although the motive is not known, and I'm not entitled to know what that is, but it looks like there was either panic or whatever, or an intentional act for whatever reason. You don't do well under pressure. The Milwaukee County case talks about, as Attorney Opper indicated, you using a vehicle to run over another person with your vehicle. So you don't respond well to what is common sense within our community, our society. So based on that, you're out on bail. Those smallish bails that you were out on didn't do very well. Before I forget, there is Marcy's Law. I understand that although there are, the statute and the Constitution now defines deceased victims to allow for family members to speak. So Attorney Opper, I was told that nobody wishes to speak. We have a number of people from the families. And is that still your understanding?
I'll just confirm that, Your Honor.
Thank you.
Yes, I'm getting confirmation. Nobody wishes to speak to the court at this time, but thank you for your
one on
inquiry.
your right. So, ma'am,
I'm sorry.
I would ask that the victim witness individual from the DA's office see who this is without divulging who it is and what relation to what victim she is. Thank you. Sheriff's Department for a warrant. While that is being discussed, I neglected to order DNA be taken. A sample of your DNA, sir, has not been taken. I am ordering that now. It may be expunged if you meet the criterion under the Wisconsin statute.
Probably gonna use that DNA, see how many other kids how many women he done knocked up and not paying child support.
I was thinking the same thing too, Jack. I was thinking the same thing.
Where are we?
We're fine to proceed. She does not wish to stay.
Okay. Thank you for checking. Thank you, ma'am. The family is always welcome. You do, under the law of the state of Wisconsin, as well as under the amended Constitution, have the right to speak at proceedings germane to the particular proceedings that we're at. So with that, I will set bail. I have no problem with the bail being recommended by the state. I'm an old guy who has been doing this for almost 40 years. DA's office, criminal defense attorney, 17, 18 years as a commissioner, both in Milwaukee and now in Waukesha. The nature of this offense is shocking. Actually, the detail I was not expecting here today, that two detectives, not lay people, detectives, not only tried to stop this, but rendered an opinion that this was an intentional act. You're presumed innocent, sir, but that's what the allegations are. And I've not seen anything like this in my very long career. It seems to be a very strong case for the state. Likelihood of incarceration, which is the other aspect of bail, is absolute. If you are found guilty of any one of these, a multitude of them, it's a life imprisonment sentence that must be meted out. So I have no problem. I just, with that bail, it's extraordinarily high, but it's an extraordinarily big case. It's an extraordinarily serious case with an extraordinary history of this gentleman, of fleeing, of hurting people, of not following court orders, not following criminal laws, not following just your societal norms. So I know that's extraordinary.
That's because he's a sociopath. He's a malignant narcissist, a mixture of a narcissist and a sociopath. He's a very dangerous person.
And with
that's
that,
not
we're
on the
going to
streets.
select a preliminary hearing date. Attorney Perry, time limits.
Commissioner, we would be waiving time limits. We did.
$5 million cash bail for 39-year-old Darrell Brooks, now criminally charged with 5 counts of first-degree intentional homicide following the mowing down of parade participants Sunday during the Waukesha Christmas parade. But Ben, before we get to more details of exactly what happened right now in the courtroom, as you're still looking live at Darrell Brooks sitting there with his attorney, we have to get to the heartbreaking news that was just announced by Waukesha County District Attorney Sue Opper that a 6th fatality has been announced, and it is in fact a child.
He's facing 5 consecutive life sentences for the charges that are on the books right now, but you would expect a 6th charge of first-degree intentional homicide to be added. We're also learning that the number of injured has risen. This was details inside the criminal complaint that just came out. Now up to 62 people who were injured after an SUV barreled through this holiday parade on Sunday. Darrell Brooks, you can see him, his head down throughout this hearing, and you could hear the sobs from in the courtroom, both from him and family members of the victims who are there inside the courtroom right now. And we heard a very lengthy criminal history that was read out, not only 3 different states, but 4 different counties here in the state of Wisconsin. And there you can see him looking straight back to the gallery where there are members of family members who are deceased from this parade as they now lead him back towards the jail.
Darrell Brooks is facing 5 consecutive life sentences with these charges, likely 6. Sue Opper did indicate the fact that she was going to be filing that 6th charge for that 6th fatality that she just announced. But as you mentioned, a lengthy criminal history. It took Sue Opper about 8 minutes to read his entire criminal history to the court there. Again, the court commissioner finding probable cause for the case to move forward. And as you can see, a lot of emotion is running high, and it's going to continue so.
And heartbreaking new details in this criminal complaint that just came out. There was some sort of domestic disturbance that police were called to, and by the time they arrived, it was too late. The SUV was already heading towards the parade route. But according to this criminal complaint, the vehicle was stopped by a detective. Before the vehicle got inside the barricades, a detective stopped in front of the vehicle, said, "Stop, stop." And that SUV kept going. And detectives say as that vehicle went down the parade route, it picked up speed, getting faster and faster. And you heard the court commissioner say, according to this criminal complaint, 2 detectives saw that vehicle appear to veer intentionally into groups of people.
So next up, Darrell Brooks' preliminary hearing will, of course, be following all of this as this case moves forward to trial. In the meantime, we are covering this story top to bottom. Families of the victims, we are focusing so heavily on that because that really is what's important here, and the recovery of so many who were injured, not just physically, but also emotionally and mentally, Ben, after seeing what they saw on Sunday. But our Aaron Mabin is standing by live for us. And Aaron, you obviously heard what just happened there in the courtroom. Give us what you're feeling, what you're taking away from all this.
Yeah, Stephanie, where I'm here near People's Park, and I can tell you there are a lot of restaurants and everything on these streets. I'm certain that the people here in Waukesha were watching that court appearance very closely. People are just getting goosebumps when you hear that more than 62 people are injured, and learning that sad news, a sixth person has now died, a child. Earlier today, I talked to the family of an 11-year-old girl. She was a dancer. She was so excited to take to the streets with their dance group and perform at the parade. She was hit by the SUV. Tonight, she is bruised and she is
So
scraped up,
sad.
but
This is
she is at home
heartbreaking.
recovering, and her family members talking to me about the panic at the parade.
Screaming and chaos as a car barreled through the Waukesha Christmas parade.
We just saw like the girls like fly, like there was just like everyone just like bursted in, like we didn't know where she was.
Yaretsi Becerra
Well said,
Montez was
Freethinker.
performing
Well
at the
said.
parade Sunday afternoon with her dance team, Extreme.
It was just like something that she always looked forward to.
She loves to dance. She's so committed to that.
Her family was waiting for her to approach when an SUV plowed into the team. Panic set in.
I hear like a lot of noise and I hear like a lot of like bump, and I just didn't know what to do. I just ran and, looking for her.
I was like, "Where's Yaretsi?" And all the girls were like, "We don't know."
I'm looking for my daughter. And, I'm sorry, it's so hard.
Emotion as Laura Becerra Montez remembers finding her daughter on the ground.
Relief that she was there and relief that I saw her eyes open.
The driver hit the 11-year-old and kept going. Her family took shelter at a bakery until an ambulance arrived.
We want answers as to why he did it, like what was going through his mind that just made it so easy.
The young dancer who loves the holidays is home recovering. Her family inspired by her strength.
It's not something anyone ever expected at a Christmas parade. It's something that we always went to, and we just know it's not ever going to be the same again.
And as the days go on, Yaretsi remembers more and more what happened to her at the parade. She is really struggling both physically and emotionally. Her family members really there supporting her. They are so grateful for the community support that they have been receiving. And on the ground here in Waukesha, as we continue to talk to people about that parade tragedy, Ben and Stephanie, it seems like everyone knows someone who's affected by this. Back to you.
It's amazing how that happens. Everyone's so close to this in so many different ways, even if you weren't directly there and directly impacted by the tragedy. Erin, thank you for that. We wish her the
Okay, that's the end of everything. Jack, you have anything to say?
I don't know why they gave him $5 million bail.
Mm-hmm.
They should have just say no bail.
Exactly. And I'm so sick and tired of these parents, protecting their monster, children and stuff. It just really bothers me. It's something wrong with you. I guess maybe because you're a monster yourself and you create a monster, so you just, protecting what you're like, I guess. Mm-hmm.
No, it's self-deception. You're deceiving yourself and thinking your kid is not the devil, but it's the world that made him this way. No, your son's the devil, and you're the devil for bailing him out.
Mm-hmm. Well said. Well said. Mm-hmm. So well, I have to say my closing thoughts is both of these two characters. I just want to show the court appearance with both of them, and you just seeing how evil Zac Stacy, just all calm and cool in the court, like, poor me, like he's such a gentleman. And then you look at this one here rocking in the flipping seat, rocking back and forth, completely out of his mind. That's why I kept showing that picture of all his mug shots. Why is he walking the streets? I just don't understand. It just doesn't add up, doesn't make sense. But anything else you have to say, Jax? I'm gonna basically end because I held everybody up here for a long time because these were two long court hearings. But I want everybody to see it.
Yeah, I mean, I'm done. I mean, these guys are pathetic, and hopefully they'll get thrown under the cell with the GP boys with Vaseline and Concoline.
Well said. Well said. So, ladies and gentlemen, thank you for hanging here because this was a long live stream. I question is, I'm going to be doing a live stream Thursday, and based on what women do for their man. It's just really sick and twisted. I mean, I believe 100% by standing by your man. I'm like totally with that. But the stuff they do just not to lose a man, it's really pathetic. It really is. It's pathetic. So we're going to get into that one Thursday evening. Okay, so have your popcorn, have your cocktails, because it's going to be one of those nights. Okay. And also, thank you everybody for being here. Thank you everybody for engaging. I appreciate it. And last question is, there's an update on Stevie J and Faith Evans. Is anybody interested in me doing a live stream on that one? If so, let me know. Or if not right now, you can email me or put it into the comment section. Let me know if you'd like to hear the update on that one, because it's a mess. Okay, so get into that one and everything. And that's just about it. That's all I have to say. So everybody have this a blessed night and a safe one. And don't forget about Thursday. Please come. If not, you could definitely watch the replay and leave your thoughts and opinions in the comment section. And hugs and kisses to everybody and blessings to everybody. Hugs and kisses to Free Thinker and Frugal Mama. Hugs and kisses. And get ready to go hit your place tonight on your channel. Yeah, I think you're doing something. You should be doing something tonight. And I'll be going over there. Yeah, I got some time. All right. And hugs and kisses to everybody. Thank you. And thank you, Jack, for being here and co-hosting. And remember, date smart, not thirsty.
Special crap like that you just showed.
How the heck would you lay down with something like, and then you not a condom? You need like 4 or 5. I wouldn't even lay down with him. That's just number one. And you gonna lay down unprotected? Ladies, come on. Have a little more pride for yourself. Your body is your temple. What the heck? You want to lay down with him and have a kid by him? You know that he's gonna be a loser dad. I just don't understand. Jack. I don't understand. Oh gosh, it's so sad. All right. Somebody said something else. All right. Thank you for the purple hearts, Teresa. All right. I guess that's about it. Let me stop running on. Check out Thursday, my regular usual commentary on Thursday nights. And that's about it. Hugs, kisses. Bye.